Adjustments and Appeals meeting. First, I'm going to call the meeting to order here at 6 p.m. Come on in. And we're going to stand and say the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ms. Kim, may we have roll call, please?
Chairwoman Smith Rodriguez.
Here.
Vice Chairman Taylor.
Here.
Member Beckles. Here. Member Van Deven.
Here.
Member Wheelis.
Here.
That gives us a quorum to conduct business. I'm going to read a little blurb to our folks in our audience. All persons who anticipate speaking on any public hearing item must fill out an oath card to be heard on that agenda item and sign the oath contained thereon. These cards are located at the table near the entrance to the council chamber, or you may obtain them from our recording secretary, Ms. Kim, up here. This meeting will be conducted in accordance to the procedures adopted in Resolution 24-1997. Those speaking in favor of a request will be heard first, those opposed will be heard second, and those who wish to make public comment will speak third. The applicant may make a brief rebuttal if necessary. A representative from either side, for or against, may cross-examine a witness. Any person who speaks is considered a witness. If you have photographs, sketches, or documents that you desire for our board to consider, they must be submitted into evidence and will be retained by the city. Those exhibits will be submitted to our recording secretary. So if you have not filled out an oath card and you want to speak on either of the two items today, please go to that table and grab a card and hand it into the end of our table here. All right, that being said, for our board, please look at the minutes. Seeking a motion to approve the minutes from our December 1st, 2022 meeting.
I motion to approve.
I have a motion to approve the minutes. Do I have a second?
Second.
I have a second. All in favor say aye.
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 And hearing 4 plus me, aye. No opposed. All right. To our staff, have our items been properly advertised?
Yes.
Thank you. And to our board, have any of our members visited the sites or spoken to anyone regarding the variance request we have today? No across the board. Okay. We do not have any consent agenda, nor do we have old business to attend to, so we'll move right into our new business. Let us turn to variance number 1-2023 regarding a property located at 505 Lucky Street. Mr. Parrish?
So the staff report begins on page 10 of your packet. So this is in regards to variance number 1-2023. This is for a property located at 505 Lucky Street. The applicant is Paul Judson. The request is to section 28-305 subparagraph C, intensity and dimensional standards of the code, to reduce the minimum required front yard setback from 25 feet to 14 feet for property in the single-family high-density R1C zoning district. The property owner is Annie Birch. Again, the property is zoned R1C, single-family high-density. The future land use on the property is medium-density residential, and the surrounding zoning on the property is also single-family high-density. The parcel is actually made up of two platted lots, Lot 10 and 3 of Block 3 of the Reed and Allen subdivision, which will be combined into one parcel. And I believe that's already been accomplished. The R1C zoning district requires a minimum lot width of 65 feet and an area of 6,500 square feet in order to receive approval of a building permit. The combined parcel will be a corner lot with an approximate area of 6,840 square feet. The new parcel will have 102 feet of frontage on Lucky Street and 104 feet of frontage on First Avenue. The new parcel will meet the R1C zoning standards. There is the one currently existing 960 square foot detached single-family home on the property will be demolished and replaced with a new 1,836 square foot detached single-family home. I'll briefly go through and summarize the criteria that you are supposed to consider when considering a variance, but I won't repeat it the next agenda item. When considering a variance, you should consider the special conditions and circumstances which exist, which are peculiar to the land, structure, or building involved in which the which are not applicable to other land, structures, or buildings in the same zoning, that there are special conditions and circumstances that do not result from the actions of the applicant. Granting the variance requested will not confer upon the applicant any special privilege denied by others. The literal interpretation of the provisions of the ordinance would deprive the applicant of rights commonly enjoyed by others. The variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. Granting the variance will preserve the spirit of the ordinance and remain in harmony with its general purpose and intent. And granting the variance will ensure that public safety, welfare is assured. So in no case shall the granting of a variance result in a change of use, which would not be permitted in that zone, and that's not a case here. So on page 12 of your packet, I'll summarize the, just read through the analysis for you. The applicant is requesting a variance to encroach 11 feet into this 25-foot front yard setback in this single-family zoning district. The existing home will be demolished and replaced with a new one. The new setback, if approved, will be 14 feet. The variance and remaining setback will be applicable to the new parcel with a new 1,800-plus square foot home as proposed in the site layout, and I'll point that out in a moment. A portion of another detached single-family home located at 1228 First Avenue currently encroaches into the subject property. The home is located on Lot 9 of the same subdivision. The home was constructed in 1957, prior to the establishment of the city's zoning and land development regulations. The home encroaches approximately 28 feet into the subject parcel. The existing home on the subject parcel was built on Lot 11 in 1966, and Lot 10 remained as a vacant lot prior to Lot 10 and 11 being combined as one parcel. The existing home would be demolished and the lots would be combined into one parcel. The applicant submitted a plan to construct a new detached single-family home, which would have been located close to the detached single-family that currently encroaches into the property. I'll point out what I mean by that in a moment. In order to comply with fire separation requirements between buildings, the applicant revised the plan by reorienting the proposed home to provide adequate fire suppression. The proposed home will require a variance to encroach into the front yard setback of the combined parcel, lots 10 and 11. The hardship appears to be the encroachment into the property by the home located at 1228 First Avenue. The variance appears to be justified as there are unusual circumstances on the subject property. So based on this, staff recommends approval of the variance to encroach 11 feet into the front yard setback as illustrated on the site layout. There are conditions and circumstances that are unique to the land and not the fault of the applicant. The neighbor's home encroaches into the subject property. The variance appears to be the minimum necessary to make reasonable use of the land. Lots 10 and 11 will be combined consistent with the R1C zoning district, and the orientation of the house will meet the intent of the code. Granting the variance will not confer upon the applicant any special privileges. So with that, I'm going to skip to a couple of sheets here on your packet just to illustrate what we're talking about. On page 13 of your packet, if you just click to that page, you'll see an aerial and the subject parcel highlighted in red. Again, this particular parcel is made up of lots 10 and 11. This is the combined parcel here. And you can see the existing home on there. That will be demolished and replaced with a new one. You can see the home just to the south of it, though. It doesn't look like it's actually encroaching on other property, but in actuality it is, and I'll show that on a survey. I'm going to ask if you could go to page 24 of your packet, and you'll see the survey that was submitted with the application. And so you'll see lots 10 and 11 combined, and you also see the existing home on lot 11, but then you also see the house, their neighbor's house to the south of it, encroaching into their property, approximately 28 feet. Next, I'm going to ask if you could go back to page 22 of your packet. And you'll see the plans that were submitted to us for the layout of the new home and its orientation on this new combined parcel. So in red, you'll see that that's the estimated area of where this encroachment is, where this neighbor's house is located on their property. The initial orientation of the home that was going to be the new home on this property was going to be very close to that rear home, to the home in the rear there. So we worked with the applicant and they agreed to reorient the building to be east-west orientation. And so in purple is the proposed location of the new home. Because of the fact that the lots are going to be combined, the definition of what is a front setback and what is a front yard or a side yard and rear yard is completely reinterpreted now. So now, according to the code, First Avenue is actually effectively the front yard, and then the front yard setback must be measured from that point. The rear yard is going to be all the way to the opposite side. There's also, because this is now a corner lot, it's going to have, or corner parcel rather, it's going to have a corner lot, or a corner yard setback. And so that's going to be measured from Lucky Street. So based on the orientation and the location of this house, it will encroach into what we've considered to be the front yard, and that's why the applicant is asking for this variance. With that, I'll try and answer any questions you have. I believe Ms. Birch, I just met, who is here to answer any questions you have as well. When you're ready.
Any questions from the board?
Yes. Mr. Parrish, with the encroachment of the existing house, the adjacent house, is there any thought of moving the property line to exclude that from this parcel?
That's possible. We believe that to be a civil issue between both property owners. So it's not something that we had asked them to consider that. I'm not sure what their if they came to a resolution on that. But we didn't see it as a reason to hold this application up.
Anyone else from the board?
And you say now this house will be oriented so that the front will be facing First Avenue? It will have a First Avenue address as opposed to Lucky Street?
Sure. The address, when they get their building permit, the address question could be resolved later on. At the moment, the address of this property is from Lucky Street, but that might change based on the building permit when they give that to us and what Brevard 911 says.
No further questions from the board? No? All right, may we have our first witness, please?
Susan Pender?
Ms. Pinder, come on up. Are those documents for us? Yes. Yeah, if you just want to hand it at the end there, and we'll pass them down. Thank you.
Ms. Pender, you're not the applicant?
You said Susan Pender.
Yes.
Oh, is there an applicant on our cards?
No, ma'am. All I have is Miss Pender and Stan Johnston for
Ms.
this
Birch,
item.
are you here?
Yes, I am.
Hi there. Would you like to speak or talk to us at all about your variance?
Sure.
Okay. I'll have you come on up, and then we'll fill out an oath card after. Okay? All right, Ms. Pinder. I'm sorry if I could put you on hold for a second. You did well. All right. Ms. Birch, would you please state your name and address?
Annie Birch, 505 Lucky Street, Titusville, Florida, 32780.
Thank you. If you just want to tell us a little bit about, if you feel inspired to tell us about your variance, you can do so now.
Okay, I put it in because I'm having a new home built, and it was denied because of the encroachment of the 1228 is on my property, 28 feet on my property. I called the owner to try to rectify the issue. Didn't get anywhere with her, so I called back to the city and spoke with Mark Jones and Mr. Parrish here. And so they figured out, along with the contractor, to go around until we get this rectified with the civil matter with the encroachment of my property. And that's about sums it up.
All right, thank you. Don't go anywhere. Any questions from our board? Looks like a no. Okay. Ms. Birch, before you sit down, would you go fill out one of those oath cards for me, please? All right. And Ms. Pinder, come on back up. And if you would please state your name and address.
My name is Susan Pender. My address is located in Texas, 8202 Meadowside Drive, Benbrook, Texas, 76116. The house that I own is 1228 First Avenue, Titusville, 32780. 80. That's in question to Ms. Birch's application of the variance. Yes, Ms. Birch contacted me to tell me the 28 feet encroachment on the property. And of course, I thought it was a scam. And at that point, I had to reach out to family members because the house was built. No, my parents purchased the house in 1955, the property, the lot. The home was built in 1957. I even have a picture of it. Nothing was there, we were like the first. And like he said, the original house, which was owned by Bud Mitchell, was built in 1966, then purchased by Miss Birch's husband in 1985. So with all that being said, I then did my due diligence and not just believe what she told me. I hired an attorney as well as had a survey done, and so that's what you have in front of you. Now, I'm working with her trying to figure out if this is true. So if my survey turned out as hers, we would have worked something out, but it didn't. And they are a reputable company, and I am believing in their work, and they're standing by it. So with that being said, we are at a crossroads, and so this is where we are now.
So Ms. Pinder, let me, well, first of all, we're not deciding any boundary issues here today. Are you speaking in favor of Ms. Birch getting this variance to encroach into the front yard setback, or are you against her, or are you neutral as to the variance request?
I'm neutral. I have no problem. All I want to ensure that there is no, because the 28 feet, I don't believe, based on my survey, but I don't want any issue now that I probably have to put up a fence and there's another property issue where your boundary is and where mine is. And based on my survey, my boundary is within the lot of Lot 9 and not approaching her.
Okay.
So,
It sounds like you do not want us to grant the variance confirming that there's an encroachment. I think I'm picking up what you're putting down. All right. Any questions, Ms. Pinder? No? Okay. Thank you, ma'am. We appreciate your time.
thank you.
Ms. Kim, any other cards?
Stan Johnston?
Mr. John, pass. He passes. Any other cards?
No, ma'am.
Okay. I'll bring it back to the board. Board, do we have any other questions of staff? Otherwise, discussion amongst ourselves is fine.
As mentioned by the chairman, this is not, as you mentioned, not a discussion on the civil part or who owns what. It's just to make the distance between the houses correct. Is that right? The reason it was oriented that way for the fire difference there?
The original orientation that was proposed to us, we thought was too close to the other house, yes. And so, working with the applicant, they agreed to reorient the house. And because of that, that new orientation is causing this requirement for a variance to a front yard setback only.
Okay. So nowhere in this will the neighbor, or our decision, just confirming to her that our decision will not in any way encroach upon their civil action. Is that correct?
I can't say whether your information will be used at all, but I can say that you could use the information that's provided to you as exhibits here, such as the survey illustrating the encroachment of another house, as helping you make your decision.
I don't
Because-
think he's asking if our information will be used, but our decision is only regarding the front yard setback period, right?
Correct, but when you look at, I'm sorry,
We have nothing to do with the backyard, or we're only looking at, as a board, only at the front yard setback, right?
so one question you could ask yourself is this the minimum variance necessary? Are there other options on the property for them to be able to meet the letter of the law? Is there some way that the house could be oriented somewhere else, changed, reshaped, whatever, in order to meet the letter of the law? If there are other options, those are things you could consider in making your decision.
All right, any discussion amongst ourselves? I'll simply say that regardless of whether there is a legal encroachment, the neighbor's house exists, and because of its existence, rightfully or wrongfully, this new house has to be moved out so far. So that alone, to me, creates a special condition that would justify it, without any regard for a legal boundary.
I agree with your conclusion.
Any further discussion? No? Okay. Anybody want to make a motion regarding the variance found on, starting on page 10?
I'll do it once I get the number in. Okay, I make a motion to approve variance number 1-2023 at 505 Lucky Street as presented with the setbacks over the front and side yard.
I'll second.
This is related to the front yard.
Front yard,
Just the
I'm
front
sorry,
yard.
front yard. Sorry.
Okay.
I apologize.
I second.
Okay, I have a motion, I have a second. Any further discussion? No? Ms. Kim?
Chairwoman Smith Rodriguez,
Yes?
Vice Chairman Taylor,
Yes?
Member Beckles,
Yes.
Member Van Deven,
Yes.
Member Wheelis.
Yes.
All right, Ms. Birch, your variance has been granted, so you can continue to work with the city. Ms. Pinder, this decision in no way affects any sort of civil dispute. It doesn't adjudicate any boundary lines or encroachments. So you both may proceed elsewhere on that. Good luck to both of you. All right, that moves us on to our next variance. I'm on page 28.
Correct. Page 28 is the variance number 2 of 2023.
Okay, so variance 2-2023 located at 4710 South Washington Avenue. Mr. Parrish?
So the staff report begins on page 30 of your packet. Trimcore Construction of Florida LLC is the applicant. This is a request to get a variance to Land Development Regulations, Section 30-337, subparagraph B, permitted uses within a landscape yard to allow for the property located in the Urban Village zoning district located at 4710 South Washington Avenue. The property has urban mixed use, a comprehensive plan future land use designation, which was approved by ordinance number 53 in 2007. And there is a rezoning, zoning on the property of urban village, which was approved by ordinance number 54 in 2007. The reason why I'm referencing those ordinances is because there are only 3 properties within the city that are allowed to have this particular zoning. The comprehensive plan and the city's code identified 3 properties such as this one, Titus Landing, and the old Searstown Mall as redevelopment sites, and actually has incorporated some minimum master planning requirements in order to allow this particular zoning district to be put on the property. This particular property was approved in 2007 with this zoning district with a master plan that continues to govern the property. North of this property, it has a light industrial and services warehousing M1 zoning district, and again to the south of it. To the east and to the west has zoning of open space and recreation. The lot characteristics, the property is approximately 30-plus acres and primarily vacant. The uses, there is one 3,700-plus square foot building located approximately 120 feet from US Highway 1. I've already gone over, summarized the criteria. The applicant is requesting a variance to allow an easement in a required landscape yard buffer. Section 30-332 of the code requires that all new development, include a 20-foot vegetated landscape yard or buffer adjacent to a public right-of-way. Specifically, the code section that's being varied states, landscape yards shall not be included as drainage, right-of-way, utility, or other easements unless the low-impact development best management practices, BMPs, listed in the Low Impact Development Technical Manual, Section 11.6, Low Impact Development Incentives Matrix, are utilized or such user are otherwise approved by the administrator, providing that the original intent and purpose of this section is met, and there are unusual circumstances provided to the administrator. The reason I put this in here is because the code specifically says that when a site development permit or application is submitted to us for new construction, that there are buffer or landscape requirements along property boundaries, especially along the public right-of-way. And the code specifically says there should be a 20-foot wide landscape buffer along the public right-of-way with the approval of a site development permit. We do not have a site plan before us for this property. All we have is a governing master plan, which effectively operates like a zoning district on the property right now. The applicant is constructing a new sewer utility line from a new lift station and will extend south to State Road 405. The purpose of the sewer line is to allow for the construction of the Riverwalk Apartments project located at 5305 South Washington Avenue. The new sewer line will also accommodate future development in the area. The sewer line will be dedicated to the city for future maintenance. The applicant is initially intended to construct a sewer line utility in the FDOT public right-of-way. However, due to physical constraints or obstacles, the applicant desires to construct a segment of the new sewer line on private property. The applicant has not described the particular constraints or obstacles that is preventing the sewer line from being constructed in the public right-of-way. In a follow-up, after this was published, I did meet with the applicant and did identify some constraints, and I'll point that out to you on a picture, and I'll allow the applicant to describe specifically what those constraints are. The applicant intends to record a 15-foot wide, 45-foot long utility easement from the owner of property located at 47 South Washington Avenue. According to the applicant, the property owner will grant the utility easement provided the city will agree to not require a future landscape buffer to be located outside of the utility easement. The applicant is therefore requesting a variance to section 30-337B to allow the utility easement to be located in a required 20-foot landscape yard buffer. The owner is also asking that the remaining 5 feet in the landscape yard buffer be located between the public right-of-way and the 15-foot utility easement. What this means is that along the property line, along the frontage of US 1, there'll be that 20-foot wide landscape buffer. 15 feet of it will be taken up by this utility easement. The remaining 5 feet will be what's left for landscaping. Now, the code is very specific, and I'll point out what the code says about the types of trees and vegetation that should be in landscape buffers. And so our staff is a little concerned that the remaining 5 feet between the easement and the public right-of-way might not be enough to be able to accommodate that. And so that might cause the property owner who will propose a future development to have to seek another variance. I did, in the subsequent meeting after this was published with the applicant, it was indicated to me that that 5-foot landscape strip would actually be on the inside. So in other words, 20-foot wide landscape buffer, and then the first 15 feet of it from the property line in will be easement, and then the remaining 5 feet will be outside of that. So it'll be interior to the site. I'll point that out to kind of clarify that in an illustration in a moment. The code specifies the number of trees and shrubs and their spacing is required in a required landscape yard. Utility easements and landscape yards sometimes limit the number and spacing of required trees and shrubs. The Water Resources Department will not support the planting of trees in a utility easement. Without a site development permit or other development proposal, the staff is unable to determine if the 20-foot landscape yard with 15-foot utility easement as proposed can accommodate the minimum number of trees and shrubs. Without a site development permit or other form of development plan, there is no evidence to support a hardship case consistent with the variance criteria described in section 34-226, which I just summarized earlier. Section 30-337 allows for the exceptions provided low-impact development techniques are utilized or there are unusual circumstances. Without a development proposal, LID techniques cannot be demonstrated to support the variance. Evidence was not submitted to support hardship-related unusual circumstances on the property. That's not to say that hardships might be there. I just believe that the applicant needs to illustrate to you what those are. The property is approximately 30-plus acres and primarily vacant. There is one 3,700 square foot building, that, as I stated before, located about 120 feet from the US 1 public right-of-way. The 2007 US 1 Corridor Master Plan, which was adopted by City Council back in that date, and identified this property as a significant opportunity for large mixed-use development. The city's comprehensive plan lists 3 large properties appropriate for the urban mixed-use land use category, as I stated earlier, and the urban village zoning district. The other properties are the Titus Landing and Titus Landing, formerly Miracle City Mall, and the Titusville Resort and Destination, formerly Searstown Mall properties. The urban mixed-use land use category and the UV zoning district require a master plan with a rezoning. 2007, a master plan was approved with a comprehensive plan, future land use map amendment, and rezoning. The master plan describes a mixed-use development with high-rise condominium buildings near the center of the property with some first-floor retail and ancillary parking lots, a large preservation area, and a tree-lined landscape area adjacent to US 1. The master plan is still binding on the property. Site plan and any development proposals are required to be consistent with the master plan. Exceptions to the land development regulations, such as variances or waivers, are typically addressed as part of the review of a site development permit. So with that, staff was unable to determine a hardship consistent with the variance criteria. Site plan or other development plan was not submitted for review. Staff recommends evidence be submitted demonstrating the hardship and whether the governing master plan needs to be amended. So with that, I'm going to try and point out a few exhibits. On page 65 is an aerial. And I'm sure everyone here is familiar with this property. It's on the other side, across the street from Kennedy Point. It's a fairly large property. It's about 30-plus acres, and you can see there's one building there. On page 49 of your packet, you'll see the exhibit that was submitted to us by the applicant. This is the proposed easement and force main relocation. One thing you should note when you look at this that you will see, and the applicant will most likely identify, there is an existing line or utility infrastructure in this area. And our Water Resources Department would like to have that into an easement. It's currently not an easement. And then in red, you'll see there, that is the proposed location of the new sewer line. On page 46 of your packet, you'll see an image. You don't have to zoom in on it on that page, but it was an image provided to us by the applicant. And those flags identify several infrastructure equipment or other lines, whatever that might be, within that public right-of-way between the pavement and the stormwater, I guess it's a swale, on the left side of this image. But I'll let the applicant explain exactly what that is. On page 53 of your packet, you'll see, I've included the master plan and a report that was approved back in 2007. You'll see the illustration of what this project was supposed to look like at that time, or what any site plan is supposed to be relatively consistent with. And you'll see that the master plan does indicate that there would be a tree line landscaping along the front of the property. So if this easement is approved, landscaping that would have to be required otherwise, would have to be, the buffer would have to be moved out of it unless there's a variance approved. And if the variance is approved, you would have only a 5-foot strip to put overstory trees, understory trees, and other vegetation that's required by the code. Now, however, I have talked with the applicant, and we have talked about maybe proposing an area, or at least agreeing to an area where trees could be put there so that, or a little larger possibly, so that we won't have to go back for a variance in the future. On page 68 of your packet, I've included the code requirement. And so this is the city's landscape requirements. And you'll see under paragraph 30, or section 30-332, there's a table titled 30-8 required landscape yard type. So on a public right-of-way, you have to have a landscape type B. And then this section refers you down to another table, which is on page 70 of your packet. And that's in section 30-335. Table titled 30-9 landscape yard standards. A type B buffer is 20 feet, and then it further describes the type of vegetation, overstory trees, coniferous trees, understory trees, and shrubs, and their spacing requirements within that 20-foot landscape buffer. Now, I will point out, if you look at type A buffer, which is sometimes only required for commercial development. It requires only a 10-foot wide landscape buffer and requires the same type of vegetation and number of vegetation. So the only difference between a buffer A and a buffer B is the width. The vegetation amount is still the same. So it does appear that even with a 10-foot wide landscape buffer, that this vegetation requirement still can't be met. With that, I'll try and answer any questions you have about this, and the applicants are also here to answer any questions.
To our board, any questions, Mr. Parrish?
This plan that was back in '07, that this was approved, that doesn't mean that is what will be built at this moment.
If we receive, I'm sorry.
It's just a plan that was submitted to get this land rezoned. It's not what's to our
Any-
knowledge, yeah.
If we receive a site plan for this project today, for this property today, it would have to be relatively consistent with that master plan. In order for us to accept a site plan for development of any type, it would have to be consistent with that. Otherwise, that master plan would have to be amended so that the site plan that we would receive could be utilized or be accepted.
I have a question. In your analysis, you mentioned the low-impact development, which is the lid. Does this qualify for that type of development? Is this a lid? Reduces impervious surfaces, and treats runoffs and peaks?
I don't think so, but I think if we go back to that language, it talks about it as being an option, of a means of determining whether that waiver should be granted.
Right.
And so it emphasizes LID, or low-impact development, as an important means of
Okay.
granting that waiver. However, at this point, we do not have anything to address it because we don't have a site development permit for the property.
Thank you.
This sewer line, is that what it is? That's what we're talking about?
Yes.
Will also serve this property if and when this property is developed?
I'm going to refer to the applicant on that one.
Okay.
Yeah,
Because my follow-up question would be, would that have been considered as part of the master plan at the time it was proposed?
I'm not sure that this was considered at the time of master plan because that's a higher level review, whereas the getting down to that kind of minutia probably would not have been involved at that time. It probably would have only happened at site plan stage. So it is possible that even with this master plan approved, and they go in with a site plan to get something approved consistent with that master plan, they might have come up with this issue. That's possible. I can't anticipate that until you see a site plan.
That actually sounds like it should have been dealt with. All right, next question for Mr. Parrish, if that any?
I just have a question. Was a site plan requested?
For development consistent with
Yes,
the,
development of this new sewer system.
no ma'am.
Okay.
Anyone else? Nope. Ms. Kim?
Justin Trimback.
Mr. Trimback? Good evening. If you would please state your name and your address.
Yes, my name's Justin Trimback. My residence, 8719 Serrano Circle, Melbourne, Florida. I have some handouts. Just to give you guys a brief background of how I got here today. Okay, Trimback Construction, Trimcore Construction, Florida. That's myself, and I'm originally from Alabama. I came down here to Titusville back in 2017, 2018. We built the Solomere Grand Apartments there on Knox McRae. I'm proud of them. I think I know they turned out well, in my humble opinion. But I think we're an asset to the city. Since that time, I've been a corporate citizen here. I haven't lived here. I've recently bought some lots in Tranquility. I'm going to build a house here if they ever get finished. But I've supported this community. And then I got the little handout here. There's a bunch of dates on there. We did well at the Solomere Grand, was looking for another site to build apartments. And I bought that site that kind of wraps around the old Space Coast Credit Union there on US 1, which is totally different than this master site plan place that the Kirk's on. But I bought that there because felt like it was gonna be another great place. I thought, matter of fact, I felt location was even better than the Solarmere Grand right there on US 1. So we go through all this, and, you know, in 2019, I'll hit these real quick. There's a staff report to the P&Z and the city council to approve it for 210 apartment units there. They changed the zoning that would allow that. And then in March, the city approved it, the city council approved it, and part of the P&Z at that time said that neither any extensions nor enlargement of existing sewer or water infrastructure would be needed to do those 210 apartments. So I go forward and I buy the place. I'm thinking, hey, this is recorded, this is good. So I move forward, I get the civil engineer in April, and we get started, we get our civil plans, and we go through this whole process. And then in March, there was a meeting called with the city officials, and I know all the guys. I mean, I know them by name, Steve and Scott, Sean, and all the guys. So they call me, and we have a meeting, and there was a lot of other city businessmen there as well. And they talk about there's going to be a moratorium on any development going down US 1 because the reality changed, and now the existing infrastructure for the sewer wouldn't support any additional growth. Well, I'm in this thing pretty deep already because I'm planning on building those 210 apartments. Well, I attend the meetings in Troy. I met Troy Post, and he represents North Brevard Economic Development Zone. And after several months, I just said, you know what? The board saying that they would give the money, but just needed a businessman, a third-party guy to come in and do it. I said, I'll do it. I'll get it done. And so I stepped up and I've done it. I went through the whole process. And during that time, we submitted our plans for our 210 apartments. Everything's approved. The civil plans are approved. Architectural plans are approved. I got slabs poured right now. I'm starting framing on February 6th. So I feel as though that a problem was identified, that the sewer line wasn't big enough. You know, I'm not even gonna get into, I was told one thing and then the reality changed, because things happen, you know? Things happen, but we had a solution with the board, the economic board working together, and I'm stepping up and saying, hey, we'll get it done. So this is a big project. It's 2.1 miles, put in a brand-new lift station up there on the Kirk's property. And Bob Kirk was generous enough, I met with him over 2 years ago, and he had to donate some extra right-of-way to put the bigger lift station on. And he did. He graciously did that. And let me catch my breath here. So we get started. So we put that big lift station in up there. If you ride by there, you'll see it. It's big enough, the diameter of it is big enough that literally you could take a Volkswagen and drop it in it and spin it around. It's that big. One piece came on, one tractor trailer, it was so big, a crane setting it in there. We've ran all the sewer line except for the 750 foot that we're asking this variance for from that lift station down toward the donut place. That's what's missing right now. Everything south of that, we've got that line in. We're about to bore underneath 405 and connect it on the far side down there. So we've acted in good faith every step of the way. Well, in November, late October, November, we discovered that last 750 foot. If you look at that picture that's there, we discovered in that 750 foot that there's huge challenges. You got the right of way off of US 1 on the west side. It's flat for a little piece. Then it drops off into that ditch, and the right of way goes down into that ditch. Well, I can't put that sewer line in the bottom of that ditch, because if we do and it ever was to break, that's a huge problem. Nobody wants that. Well, then I've got to go on the right-of-way portion, and you see all those flags up through there. There's FPL lines there, there's sewer, there's water, there's a gas line, there's communication lines, all those things are there. Well, I meet with Brewer Paving and Development, they're doing the work for me. We literally, if you get out there and hand dug it by hand, guys with shovels, hand digging it by hand to do this, you're not going there. You got to have so much clearance between all these different lines to put your line in. So
it was like impossible to make it happen. So at that point, the other choice was, hey, if I can't, can I bore it? Can I bore it? And just go deep and bore up underneath all that and come up by the lift station? Well, I was denied that request to do that. And I can understand why, because if they ever had a break in that sewer line, how is the city guys gonna dig down through all these existing lines to get to that to fix it? So that's common sense to me, it makes sense. So at that point, we went back to the Kirk family, and, Bob had passed away, went back to the Kirk family and asked them, hey, would you guys grant an easement, utility easement, just to the west of the existing easement, so we can come up on the west side of that ditch, and we can put the sewer line in through there. That gets it where there's, won't be no other pipes or lines in the way, and we can get it in quick and easy. And then if there's ever any problems, because something breaks, the city could get in there without any delays to get in there and get it fixed. Well, the only thing that the Kirks asked for in return was that, yeah, we'll donate this easement, this 15-foot, but, there's a 20-foot buffer that has to go up through there, the landscape buffer. We just asked that 15-foot counts toward our landscape buffer. Sure, it leaves us 5 foot of the 20 that's left on the west side there. And they said they'll get whatever they got to get done, they'll get done. They'll get it in there. But in my humble opinion, I think, the economic board stepped up trying to help the city with this sewer line. I'm doing my best to get this thing in. The Kirk family has been very generous, in my opinion, to try to help. And I don't think what they're asking for is a stretch, just to be able to count that. And, I would ask for you guys to please consider that. If we get this lift station in, it helps. I don't want people, sure, this helps me on my apartments, no doubt about it. I've acted in good faith every step of the way, no doubt. But it also helps the entire community, because we can get more economic growth up and down that corridor that right now nothing can happen because the sewer capacity is not there. It also alleviates issues with sewage to the north of the existing lift station now. That, it's not a secret, there's issues with that. But it's a win-win for everybody. The city wins, everybody wins. And I just would ask for y'all's humble help in this and to grant this variance.
So there's an existing sewer line, yes?
There is a existing sewer line that runs through this area that I was led to believe that would support my 210 apartments when I built it. And then the reality changed, that they said that the capacity in that line wasn't there anymore. So that's when I stepped up with economic board's help and said, I'll do it, I'll fix it.
Does your proposed line, is that a second line, or that's supposed to replace the service of the first line?
Okay. Currently, there are some businesses to the north of my area, Falcon Marine and those areas up that way, and some houses back there. There's a line that runs in the ground already, and it runs over to the existing lift station next to the new one that we put in. I mean, it's just that close, just real close to it. That runs up there, existing already. That's what I was led to believe that
What
I
I'm
could have
asking
connected
is,
to.
you're proposing to put a line. You're not proposing to take out the other line, right?
No,
Okay, are both those lines gonna be functioning, or is your line going to overtake
Yeah.
all the
It-
service?
Justin, if I could, would you mind me jumping in just to help explain a little
I'm
bit?
sorry.
Would you
Yes.
mind me jumping in to
No,
help?
please, help.
Okay. Hi, Sean Stauffer, Water Resources Director for City of Titusville. So there is an existing line that is currently on private property. And I think if you look at page 49, you'll see that. So that line is a gravity sewer main. That is part of the original construction, probably from the 60s, and serves the developments that are there now. The sewer line that Justin is proposing will actually be a force main. Okay, so it's a different kind. That's a pressurized pipe, and that will actually end up pumping south. Okay, so so they are both sewer lines, but they will have different purposes. Okay.
But they will both remain in operation.
That is
Assuming
correct,
this one
yes,
goes through.
because the basics are the gravity lines, the existing ones, it flows downhill into a wet well, then there are pumps that put it into the pressurized force main, and then that sends it towards the wastewater plant.
Other questions for Mr. Trimback? No? All right, thank you, sir.
All right, thank you.
Ms. Kim?
Woody Rice?
Mr. Rice? Please state your name and address.
I'll wait till they get it. Good evening, y'all. Woody Rice, 505 Indian River Avenue, Epic Consultants of Florida. And I'm here tonight representing actually the property owner, the Kirk family. And I just would like to go over a few things that are in the staff report and some things I think are material that would help you make a good, solid decision tonight. I think that's important. So the first thing I'd like to go over, and I think some things, Mr. Parrish alluded to a few things that were not in your staff report. The applicant alluded to a few things, but I'd just like to go over everything that I saw in the application and the staff report. On page 3, line 2 of your staff report, and I don't have the page number in your agenda, I apologize. It talks about what this line is for. And it clearly says it was for Riverwalk and future development, which is true, it is, but it's so much more than that, okay? In reality, it actually solves an existing sewer problem north of Highway 50 for the city of Titusville. That's why the moratorium's in place, going south, because they're overflowing gravity lines north of Titusville. So it fixes an existing city problem. It places an easement over an existing gravity line that has currently, going to the south, that currently has no easement. That is public also, so it solves that. On page 3, line 8 of the staff report, it says the applicant has not identified specific constraints that are why it can't be placed in the right-of-way. So I think this picture, it's there, you've already seen it, someone else handed it out, but it shows all the little utility lines that are in there, and there's all kinds of things in there. So I'm going to show you what's in there. So, and this is just the city infrastructure that's in there. So go to figure 2, okay? And what you will see is here's the current lift station, the little LS that's on that thing. There's a force main that runs north, the existing force main that runs north. That's what's getting rerouted and going to eventually head south. There's this line, this light green line that runs all the way, and it's the existing 8-inch gravity line that Mr. Stauffer shared with you. So that's in there, and that's the one in the south that doesn't have an easement. There's also a 10-inch water main that runs in the right-of-way, okay, along there. And that's extremely important because there's certain separation requirements for a force main or any, sewer line and a potable water main. And I'm going to go over that with you. And then the other utilities that are in this in this picture with the flags, there's a power, gas, and communication cables that run all through there. Now, the separation that you have for force main versus sewer, the minimum is 6 feet separation. So, and it's not center of pipe to center of pipe. It's outside of pipe to outside of pipe. That's DEP standards. They prefer to have 10 feet is what they really want. But in particular circumstances, you can shrink that down to 6 feet. okay? There's no room. The other thing I think that Justin referred to is the roadside ditch that runs along here, right here, it's a roadside ditch. And he tried several different options and was denied for good reason. And I think he stated what the reasons were, why it just wasn't practical to do that. So the only thing left was to ask my client, okay, for additional easement, 15-foot easement to run this sewer line in. So I just want to go over now on, what has the Kirk family already done? What have they stepped up to do to be a player in this and try to help the city solve their problem, help the sewer problem that has a moratorium south of 50? So that takes us to figure 3, which is an easement that's already been recorded and accepted, okay, by the city. And this easement here is for the city. And it actually is part of an existing easement, but expanded the easement because the lift station is much bigger than the old lift station. So expanded that. The Kirks did that at no cost to the city. Well, then after that was done, FP&L comes along and says, hey, we have to put a transformer in to service the lift station, okay? And so Mr. Honeycutt actually said, well, we're going to put it right here inside the lift station easement. And FP&L said, well, no, we don't want an easement inside of an easement. So Mr. Kirk then again stepped up again and said, all right, we're going to give you a separate FP&L easement now to the south. That's even more land now that's already taken out of it. So that's figure 3. Figure 4 just there for information. It sort of shows what the city lift station is going to look like, and it shows where the FP&L transformer is going to be servicing the lift station. That's what figure 4 is all about. So that takes me on down to, I think Brad actually mentioned this. This is the easement that's being proposed, okay? It's not 45 feet long. It's 755 feet long by 15 feet, 0.26 acres of land. That's buildable land, okay? That if you make me push this easement out any further, it's basically you're taking more buildable land away from the Kirk family that they've already generously given some already. That's a material defect on a contract they currently have with selling it. I've been trying to help Jesse clean up some of the things that Bob left behind, her late husband. And we finally got through St. John's, and we're just trying to get these contracts moving forward because she would like to resolve a lot of it. She's not a developer. That's not what she does in life, okay? So 750 feet, 55 feet long. The thing that the developer, we already covered that, but remember, I told you about the water main and the separation. That's key, because it won't fit in the right-of-way. It just doesn't work. And Justin's already verified that with his contractors, and they all said it would not work. So you ask, all right, well, what are the hardships? Well, I came up with 4 pretty reasonable hardships. The first one is the city needs the easement to solve an existing sewer issue of existing lines that are on the Kirk's property already with no easement. Okay, so the city needs it. There are already too many utilities in the right-of-way to place the force main in the right-of-way. That's a hardship. Can't be done. Without the easement, the new lift station may not be able to serve the US 1 corridor from Highway 50 south without major changes. There's no practical way to connect that last 755 feet. That's a hardship. Taking of buildable land from just the Kirks after they've already given land that no one else has given land. The developer stepped up, and bless his heart, and said he would put this thing in. The zone stepped up and said, we're going to help pay for this thing. We're just asking the city to step up now and grant a variance. That's the only thing we're asking the city to do. So in my mind, this is a win-win solution for everybody, and everyone has contributed to the solution, and we'd like the city to contribute too with the proof of this variance. We ask for your support tonight, and thanks, and I'll be happy to answer any questions.
Thank you. Does the board have any questions for Mr. Rice?
Well, just a matter of inquiry, this force main, when you say it goes south down to 405,
I'm sorry?
this force main?
Yeah.
Is going to south to 405?
I think
Is
Sean can
that the
probably
route
speak to what
that
the
is
issues
now
are better
going?
than I can, but it's my understanding that the new force main is going to go south now, not go to the north at all anymore.
That is correct. So currently, the existing lift station that's there, it's an older lift station, probably built in the 60s, Florida Wonderland time period. It currently pumps north and dumps into a gravity manhole just on the north side of the New Cumberland Farms. And then that material then flows by gravity to a lift station at Country Club in US 1. And so, of course, that's Indian River City. So we have a lot of clay pipe. We have a lot of I&I in that area. And, you know, that is part of the reason why we didn't want to introduce additional flows to that basin. In particular, the concern is the lift station that's right at the corner of Country Club and US 1 is also located right next to a storm drain. And that storm drain goes directly out to the lagoon. So the plan is to, you know, we can't change that whole gravity system up there, but what we can do is we can stop adding additional sewage to that system. And so, you know, part of this project, the zone and what Trimcore has put together, we're building a larger lift station, and that force main will now go south and connect to a large force main that is on the south side of 405, which is a 12-inch main, and then that will pump to directly to the Blue Heron plant.
So that will take pressure off the line that is now going north? Is that, I'm hearing it's
That the force main that's going north will be completely abandoned.
okay.
All sewage will now flow south. So that
Okay.
means we're collecting everything at that intersection 50 south will now all head south. The other thing is now we will have a new force main that will run down US 1 all the way south to 405. Whereas now there is no sewer infrastructure whatsoever. So without any infrastructure, if a development wanted to be built, you would be forced to put in a septic tank. And I believe this project has had at least one development. I believe it's the Titusville Ballet, TBJCC. You know, they're building a new building down there. They were originally going with septic tank, but because of this project coming up, we're able to put them on a private lift station. And so they will now have regular sewer service from the city. And of course, they're on the river side of US 1. So we're already seeing not only development and job benefits, but also environmental benefits too. So like Woody said, this is a win-win, and certainly speaking for the utility, we would love to get that old line under an easement. We think it's best, the current design, what they're looking at for the force main, because if it's difficult or, you know, if you can't, where this corridor is, we have to have the ease to get in there and work on it. And any, you know, if we have a break, every minute is important because this ditch that's right there flows into a storm drain, which flows directly to the lagoon. So if we've got a problem, we want to be able to get down there as fast as possible and not be hindered in our repairs. Okay?
That answers my question. Thank you.
I'd just like a clarification. I'm trying to understand. You said what would be abandoned? The old line will be abandoned.
Yes, the existing force main
Okay.
that flows north from the Kirk property and then ends up sewage flowing to a manhole behind the Cumberland Farms.
Okay.
It might,
There's a dark green line that runs from that lift station and heads north right there. That's the one that's being abandoned. The other light green line is the gravity sewer that will remain.
Okay. All right. Thank you.
I have a question for staff, for Mr. Parrish. Given this variance to allow the easement to be as described, procedurally, is there another avenue for compliance after this is granted? Or is it going to require another variance for development of the Kirk property?
I can't say for sure that another variance would be required in the future. I just know that from past, that 5-foot, remaining 5-foot line strips are usually not compatible or you're not able to accommodate the required vegetation, so we don't always have to typically receive an additional variance request to reduce the vegetation requirements. So that's what I see. So, it's up to the board how you want to do this. You have the right to approve variances or approve variances with conditions. If you approve this variance as is, we'll just see what happens when a site plan comes before us and see whether they can comply with that vegetation requirement.
So this project, or this discussion we're having, this is way bigger than landscape buffers, because the water in the city, as we all know, is problematic. Its flow, the Indian River, how many fines have we suffered? It's a train wreck. And I don't know what's being done about it and how it's working, but it always seems like 2 steps forward and at least 1 step or 3 steps backwards, I don't know. But we're not here on any of that. We're here about landscape buffers. But let me ask you this, Mr. Parrish. If I'm understanding everyone's testimony so far, there's a moratorium on building on this section of the city, yes? Is that true? For use of that water line?
For the sewer
sewer
section, yes, we're not allowing any new sewage into that collection system as it stands.
Okay, so effectively that means a site plan or development plan for the Kirk property could not happen right now because of this existing sewer line. Is that correct?
That is correct.
Okay, so, and anything that's building right now would need a septic tank. You were talking about Titusville Ballet and Jazz, they would need a septic tank, but now they don't if this line goes through.
I believe the TVJC building would connect farther south on the force main, and that is part of the greater part of the project.
So is it possible for a development or site plan to be submitted on the Kirk property and the way that the master plan suggests, but then it run off septic tanks?
I won't speak for, I wouldn't think that a development of that size
I wouldn't think so.
would be able to be handled through a septic system.
So there's a site plan that we are bound to follow from 2007,
There's a master plan.
a master plan.
Which is
I'm sorry,
conceptual,
yes.
and let me just clarify, any site plan, just so everybody understands, does not have to be exact, as what you see on that master plan.
It's
That's
gotta
just
be in the ballpark.
correct. Yes, ma'am.
Okay. So in order to comply with the master plan, you can't unless there's a sewer line. Unless this sewer line comes through that can remove the moratorium to allow buildings to happen, we're actually talking in circles now for 35 minutes. Am I right?
No, ma'am, I don't see it that way. I see, when you're asking for a variance, they're asking for a variance and trying to justify a hardship. Hardship could be that there's something unusual about the land that's keeping them from meeting the letter of the law. Now, that's okay. So there's some issues in the right-of-way that's preventing them from being able to put a line in this location, in the other location.
Right.
So they're putting it on this private property. Now, the question is, they want to have an easement inside this landscape buffer. And the reason why the applicant's asking, or the property owner's asking for a variance to this is because they don't want the possibility in the future for when they submit a site plan
Right, totally
that
get that.
will ask them for an additional 20 feet to help meet that 20-foot, the landscape buffer outside of that easement. I can't say that will happen or not. I'm not sure. I'll have to see that. I don't, only gets determined when we see a site plan to figure out what processes they need to go through.
The
So-
ideal outcome is basically a site plan that includes this. If the person was building everything and their sewer line, they were doing it all at once, that would be the ideal remedy. But that's not the case, right?
Correct.
Yeah.
So the conundrum here is do you believe that there is a justification for the variance now? Is that a concern for you in the future as to whether that's going to be pretty much automatically going to be causing the property owner to ask for a variance in the future, because they could come back and say, look, I've got this, you allowed me to put this easement here in this, or there is a recorded easement, a new property owner, say there's an easement inside this required buffer. I can't comply with the landscape buffer. Now grant me a variance to the vegetation requirements. So that's the question. If that can be resolved today, you can do that with conditions of approval. Otherwise, you can approve the variance as is and just allow that question to be answered later on, the future of the site plan. One thing I did notice when I looked at this was that there was 30 acres of land. They could add a little bit of land on the back to make sure that there is a wide enough landscape strip potential for the future development. That could be a condition of approval of this, if that's what you want to do. That's up to the board, how you want to decide this. You could decide this basically just on what the merits of what the evidence that's being presented to you tonight, and then allow that later decision to be determined later on with a future site development permit.
But a future site plan will not be submitted because the sewer line is insufficient. Is that correct? Right.
Yeah,
Of
so
course, I mean, as of right now, indefinitely until something, there's a moratorium on that section, right?
we can receive an application for review, but we can't issue an actual certificate of permit approval of it.
Right.
Until that sewer line or any other sewer connections are resolved, which can be dealt with during the site development permit process too.
Oh. Mr. Wilkes, go ahead.
I believe in speaking about expanding the developable area, they're going to run into some significant wetlands area behind the area that's proposed for development.
I could address that.
Yeah, come on up.
We've been through 3 years with St. John's resolving wetland issues, and we finally got this thing settled just at the I think it was November of this past year, after 3 years of consent order and mitigation and going back and forth. And yes, there's wetlands all in the back that are going to be protected, and that line is fixed, and it's not going to move. Okay? That's where we're at. And Miss Kirk and the Kirk family are not developers anymore. Bob was, but they're not. So the developer that's going to end up giving a site plan to staff to review is not here. It's under contract, but it hasn't been closed. So, he doesn't have anything right now to present to you on that. So it's just something that, if this isn't granted, then it's a material breach of our contract that for sale, and Ms. Kirk can't grant the easement because of that. Or she loses the sale. But catch-22, if there's no sewer capacity, she probably loses the sale also.
I have a question. On this first picture, the ditches behind where the proposed sewer line. What's beyond that ditch?
That's the Kirk, the property line's right on the other side of that ditch. That's the Kirk's, that's where
I understand they donated the
that's where the new
15-foot.
easement would go, just on the other side of that ditch.
Yeah, right, this part right here. Other side. Got it. Okay. Thank you.
All right, any other questions for this witness? All right, next card.
Troy Post.
Mr. Post, do you have anything new to offer?
I'll just say real quickly, so.
Name and address, please.
My name is Troy Post, 7101 US Highway 1. And I'm the person who manages the tax increment financing district for the city. We call it the Economic Development Zone. But this project came to us about 2 years ago. We were presented with an opportunity to work with a private developer. We incentivized them to put in the sewer because, as we understand it, the city doesn't really budget monies to do new sewer construction. They just work on maintaining existing lines. So we saw this as an opportunity to open up that whole corridor of US 1, as well as also doing some things to help the health of the lagoon by not taxing the capacity of that sewer line. We think it's a great opportunity. We were told, I think, by Sean's staff that if the city had to contract out to do this, you might be looking at an expense of $3 to $4 million. So coming in and working with the private developer, we were able to do that for much less, about $2.2 million. It went before our district board and was approved, then we brought it before the city council and they approved it unanimously as well. So we think it's a good project. We've enjoyed working with Mr. Trimback and Sean and staff, and we would request that you grant the variance in this case. Thank you.
Thank you, sir. Any questions for Mr. Post? No? Okay. Other cards?
Stan Johnston.
Mr. Johnson, before you come up, can I ask a question of staff before you come back up? Mr. Post had just mentioned that if the city was to do this themselves, X amount of millions of dollars, does the city have to get a variance from itself to do this? Had the city done this project? Could the city have just put the sewage line where they wanted to?
Well, in this.
I already felt like it was a dumb question.
In
Your
this
face
case,
is
no,
concerned it was a
because
dumb
we would
question.
have put, well, for constructability's sake, what we're looking at now is we would have put it on, we would have had to put it on private property. Because if we were constructing it in the exact same manner, this is where we would go. And we would probably, the city would reach out to the Kirks and would probably explain, this is the best place to put it, this is the best, easiest for construction, easiest for maintenance, and would also solve an existing problem where we have a utility line encroaching on your private property.
And essentially, the city would buy it as opposed to get a variance from itself.
Certainly, our first request would be a donation.
Okay.
Can I have one,
Yeah.
one more question, staff, regarding landscape buffer, the trees or whatever vegetation that was originally going to go there? Can it go somewhere else so we don't lose that?
It could outside of the easement,
Okay.
but I guess the question from the property owner is, are you going to require, when they submit to us a site plan, are we going to require them the full 20 feet outside of the easement? They want to have that question resolved now before they grant this easement.
Thank you.
Okay. Mr. Johnson, did you have comments?
Yes, I do.
Come on up. Name and address, please.
Stan Johnson, a professional engineer. I worked for the city for 7 years. And I don't know anything about this other than what I've just heard tonight, and I'm shocked. And I didn't plan to come here to speak on this, but I'm going to anyways. And I'm looking for some sympathy and mercy for the public who is burdened by what is happening with our Water Resources Department.
Mr. Johnson, are you for or against the variance?
I'm for it. I'm
Okay.
for it.
Why don't you-
Fact is, I believe what you should have another reason for granting a variance that's not listed on there. You should have reasons for granting a variance because of bungling and bumbling of the city of Titusville. That's what I've seen. In other words, the city of Titusville is supposed to have a master plan already. They're not supposed to have it. Fact is, for years now, I have been repeatedly asking questions. I said, I believe you're going to have a moratorium. I'm going to have a moratorium. I've never heard of this moratorium until tonight. I'm shocked. I'm sorry, I'm really shocked that Mr. Stauffer and Water Resources would come up with shocking because they're supposed to plan, master planning and so forth. I disagree with Mr. Troy Post because the city is supposed to be planning ahead. And right now is what you mentioned, I don't know your name, but right now is we're having all kinds of sewage spills that are being denied by the city of Titusville. False
So,
reports.
Mr. Johnson, let me stop you for a second. Are you making a presentation after the close of our variance business today?
Beg your pardon?
Are you making a presentation or a request from the public after the variances that we have today?
I'm speaking under the petitions and requests.
So I would kindly ask you to focus your comments specifically on this variance so we can address that issue before.
That's
we
what
go
I'm
to
talking
your-
about.
Okay,
No,
so
this
specify to
is.
this property, please.
No, this is, in other words,
All right, thank you.
and I'm talking about, when I said about granting a variance for reason for it, because I say our Water Resources Department is incredibly deficient and negligent. It's unbelievable what they're doing. And I just gave you another example of, for example, the sewage spills that are unreported, that are falsely reported to FDEP. They're horrible. That's just another example. And they took down a water tower on South Street without calculations presented to council. I mean, I talked to previous ones who were resources director, they said, we shouldn't have done that. Shouldn't have done it at all. Unbelievable. So we have a horrible problem in the city of Titusville. This should have never happened. People shouldn't buy property, then you come up with a moratorium like that. It's crazy. You're nuts. You're supposed to plan ahead. The city of Titusville is supposed to be responsible for that, and knowing what the value, this $2 billion or whatever it is to endure it. And it's the same for the water. Same for the water. We're going to have a moratorium somewhere about water because the city of Titusville is not planning ahead, although they get millions and millions of dollars for all kinds of things like services from consultants and so forth. It's very disappointing to me. And right now, for example, I worked for the city for 7 years. And I always returned emails, phone calls. Water Resources doesn't return emails and phone calls. And then haven't been doing it for years. It's horrible. So I want you to know is we have a horrible situation here in the city of Titusville. It's incredibly deficient. It's bungling and bumbling by Water Resources Director and other people in that. It's dishonesty. Thank you.
All right, thank you. Any other cards, Ms. Kim?
No, ma'am.
All right, bring it back to the board. Any other questions of either gentleman at the table? All right, discussion amongst ourselves.
I don't see this but anything but a win-win for the city of Titusville and the fact that private industry has come forth and sought a means with the zone and all to make this happen. And taking the load off what's already there is a great feature to me. So I'm in favor of this.
I'm concerned about our codes and following, the regulations. But I think a burdened hand is worth two in the bush. So if this is a way to correct a ongoing problem, then something we have to consider.
Looking at the criteria alone, it doesn't look like this should be granted. But all of this extra evidence that we've received today regarding a moratorium, regarding unable to build, regarding the impractical use of a septic tank, and then burdening the next property with some sort of landscape issue. I mean, what we're asked to do is to bend the code to grant this request, which admittedly is a reasonable request. We are then asked to use a crystal ball as to deal with a landscape buffer for future use of this property with no sort of development or site plan, without knowing how big these trees are and where they're gonna put and what line those roots are gonna break. And I guess Mr. Rice is representing the Kirk family today. So, I mean, unless he has some sort of inspiration to say, we'll let you have a 10-foot landscape buffer, so this way, the next variance that comes back can say, hey, we kind of meet category A, we're in the ballpark. I think
But 10 feet would
we're
have
going
been,
everywhere.
you wouldn't need a variance for 10 feet.
It needs
I
to be
think
20
for-
feet right now.
I thought for residential, but for commercial, didn't it say 10 feet?
This is property zone B, it said 20 feet.
I thought-
It would seem that the board generally thinks the request is reasonable. The question is, what sort of decision should be made regarding any conditions if needed? And correct me if I'm wrong, anybody from the board. Does our board want to talk amongst ourselves at any point right now on this topic? Otherwise, I'm intending to invite Mr. Rice back up.
And I'm looking at grounds for granting a variance. It seems like this falls into, in granting the variance, public safety and welfare must be assured and considered.
Public welfare. Mr. Rice?
if
What-
the board so desired, I do have something that might help, okay? You know, we just can't expand the landscape buffer, but what I think we're not asking to get out of the material that's supposed to be in the buffer. And we wouldn't have a problem taking that material and planting it where it made sense throughout the site, the same material, so you're not lessening material that would normally go there. We would still want to plant the 5 feet with things that we could agree with water resources on, you know, what would be good for their water line and the plants along that 5 feet. But anything that didn't, we'd still do the same trees, the same everything that normally would be planted there and distribute them throughout that site. We're not asking to get out of that requirement.
Okay, as much as you can squeeze in the 5 feet that's remaining, the rest elsewhere. And you're authorized to bind that property with this variance, which will then have to deal with your
Because
future sales.
it's not a material defect of the contract, because if I had the 20, if the force main wasn't even there, I would still have the same material I have to plant. So it's not a breach of the contract, it's the same material, okay? We're just going to distribute it differently through the site, if it so wished this board.
I think that's what we kind of done with the old Titus, Cedartown Mall area. We've redistributed. Remember that? We looked about moving some trees to different locations instead of just right on the edge.
It will require another variance in order to adjust the locations of the landscape buffer material.
That's what what I'm hearing is that you suggest a condition of this? Is that what I'm hearing?
Would that be a condition?
That's what I'm
Well,
hearing.
that,
Okay.
I would oppose it. I would not, staff doesn't support that from a planning perspective because that's anticipating a need to distribute vegetation that is technically supposed to be in a buffer somewhere else in the site without benefit of knowing what that site's going to look at. So you don't have a site plan to determine that. So if you're going down that route, I would just suggest going down the route of disapproving the variance and allowing that question to be dealt with in the future. And if there's a variance that's needed at that time, let that happen, be determined at that time.
That is also my thought at this point. They can argue whoever they will be, can argue their hardship is, we put a sewer line on their property. All right, any other discussion or questions or comments from the board to whomever? All right, when someone's ready, I'll entertain a motion on, I think you can look at page 30.
All right, I make a motion that we approve the variance number 2-2023 for 4710 South Washington Avenue as requested, which would make it just the 5-foot buffer.
Can I clarify, your motion is to
Yes.
allow the requested 15-foot utility easement inside the required 20-foot landscape buffer,
That's what I was
Along
looking for. Thank you.
the right-of-way?
Yes, along the right of way. Thank you.
All right, I have a motion. Do I have a second?
I'll second the motion.
I have a second. Any further discussion amongst the board? Hearing none, roll call, please.
Member Beckles?
Yes.
Member Van Deven?
Yes,
Member Wheelis?
Yes.
Chairwoman Smith Rodriguez?
Yes?
Vice Chairman Taylor?
Yes.
All right, gentlemen, your variance has been granted. You're free to stick around, you're free to head out. All right, that'll conclude the new business that we have. The next item on our agenda would be petitions and requests from any public present. Mr. Johnson, I believe, is still present with his request. Ms. Kim, is there any other?
No, just Mr. Johnston.
Okay. One more time, sir, with your name and address, please.
Stan Johnson, 860 Poinsett Avenue, Titusville, Florida.
Would you please first
Professional
tell us
engineer.
the topic so we can follow you?
Topic is SNJ Oaks, 3-acre parcel, 28 townhomes. It looks like what's going to happen is that there's numerous violations of law by the city of Titusville. I'm coming to you because anticipating it, because I don't know what the heck the city's doing. It's unbelievably strange. And so I'm coming to you. Maybe you can shed some light on it, what the city the heck is doing is because what they're doing is approving things that are in violation of code. And I've talked to, for example, Mr. Broom about city violating laws, and I said, well, there's no way you can do it. You can't come to the city and say that the city's violating laws. They just do what they will not prosecute the city. The city will not prosecute itself. So what we're going to have. So I talked to code enforcement saying, what are we going to do? You got a site plan. It already violates code. I can't believe they're doing this. So this is what the case is with SNJ Oaks, is that we have they've got a Mockingbird Lane there that say it's a driveway, and right now the approved plan has a 10-foot wide driveway, a 12-foot wide driveway within a proposed 10-foot easement. That's impossible. And not only that is where this driveway comes to meet Elizabeth Avenue, it does not meet, the driveway does not meet the technical standards of the city code. Doesn't do that. They don't even have a public utilities easement for houses that are on this dead-ended street. They don't even put the name of it, which is on the of this Mockingbird Lane, which is on surveys by the city. It's on our street maps. It's on property appraisers. It's on Google Maps. It's got mailing addresses of houses on the street. It's a dead-end street. And what it does is our fire department, what they did is that they don't put a turnaround on it. And it's not even, they changed it for the most part, it's two-way. And now they changed it to one-way. So what happens when a car pulling a boat meets a car or an ambulance, let's say a car that's pulling a trailer?
Mr. Johnson.
How are they going to back up?
Mr. Johnson,
Yeah.
I want you to skip to the end. What are you asking our board to do? What is your specific request to our board so I can follow your presentation?
I'm looking for advice. Advice because I'm at my wit's end with the city of Titusville. They do not return my calls. They will not meet with me. They will not return my emails on this issue. They don't do it.
I will give you advice on that topic.
Yeah.
Mr. Johnson, you are a very well-known citizen to the board, to city council,
Thank you.
probably to every department in the city.
Yes, sir.
And
Yes,
I would
ma'am.
imagine that there's a lot of shuddering when you present yourself or you call. And I know why they're shuddering about that. You present yourself very passionately. And I think what might help you relay your information, like when I ask you these questions, start at the end, tell us what you want,
Yes,
and then
ma'am.
slowly work through to be a more organized thinker instead of a passionate speaker. I think you'll get more responses that way. Because you come here very passionately, and I agree with some of the things you say, but there's so little things that the Board of Adjustments and Appeals can do. And so I'm happy to hear your statements, but I'm unable to do anything about that particular road or particular turnaround. I'm unable to go to the departments of the city and force them to answer your emails. So I hesitate to have you continue your presentation when this board does not sound like we can actually solve that specific issue that you're talking about today.
Well, in the way I'm saying, you may call it a specific issue, but I want you to understand, I used to work for the county for many years and the city of Titusville for over 7 years. And I returned phone calls. I would meet with people. I returned all emails. And the city of Titusville used to be called the city of service. It's now changed its motto. And now I'm coming to the city of Titusville, and I'm asking questions, and they won't answer, even if I come. I don't think it has very little to do with, let's say, passion. I would like some answers, and it's not getting. For example, in this case, is that this is for R3 property. they're putting this Mockingbird Lane in, the city of Titusville is approving it, let's say 12 feet wide or whatever like that. And I want you to understand is that for a stem lot, for a single-family flag lot, the stem is, the minimum is 25 feet. And they're only giving like 12 feet for several houses on R3 property. This is complete nonsense. And what I'm coming to you is I'm approaching you on nonsense. Nonsense and negligence by the city of Titusville. It is far beyond what I can in any way imagine. And not only that is what you've heard about me is my presenting of dishonesty about, for example, the city manager. Flagrant, open dishonesty, unbelievable, open and notorious about, for example, the sewage spills. So I'm at my wit's end with the city of Titusville. I don't sleep well, and I think, and I talk to some people and staff. They don't sleep well either because they feel guilty and shameful what they're doing. So what you just saw with just here about the moratorium, that's complete nonsense. I have been asking about moratoriums on a regular basis, saying, "Hey, man, you looks like you're going to head for a moratorium." No, we're not going to do it. Not going to do it. This guy who just came here, I explained to him, he's a victim of city's nonsense and negligence. This is horrible, and so am I. And so are these people on SNJ Oaks, this townhouse project. I can't believe what's going on. So I'm coming to not just you, but there's 4 other people here. I'm saying, what can I do? Not just, okay, you've given me advice, don't be so passionate. Try to talk level-headed and so forth. And I mean, I put them in writing. And I thought, I'm copying to you, but maybe you're not getting it. Apparently you're not. I don't remember seeing your email on there. I'm trying to copy all these people on DRC but I don't, do you get my emails?
I do not receive them, and nor should I. It's not something, I have a very limited task here with the city. This board has a very limited task with this city.
Well, something's wrong because when I send, well, I want you to know by the sunshine laws, I'm trying to send everybody. I know these two men, and I'm sending them. In other words, the sunshine law is when I send to one or well, if I send to 2, I have to send to all. Sunshine law. So I thought I was sending it to you also.
Mr. Johnson, we appreciate your interest in the city.
Okay.
It's nice to have people who care that much.
Thank you.
We have a very limited job here.
Thank you.
I appreciate your time.
All right. God bless you. All right. I want, but if you come to think of it, because I'll get my list again, and you'll be receiving my emails.
All right.
Thank you.
Good luck to you, sir. Thank you. Any other cards, Ms. Kim?
No, ma'am.
All right. Any reports?
You just have one application we received for your March 1st meeting. That's your next meeting.
And I believe we have a semi-annual report to approve.
Correct.
Do you know the page number?
75.
Thank you. Oh, is it the very last page? Almost. All right. This requires a motion?
Not necessarily.
Not
No.
necessarily, okay. All right, so if everyone just wants to peruse page 75, 76, so forth and so on, it'll be submitted to city council, right?
Right.
Yeah, okay. So anybody have any comments regarding this being submitted to city council? That they feel compelled to put on the record? No? Okay, Mr. Parrish, I think we're good with it. All right, and if there's nothing else from our board, no, then we can conclude and adjourn our meeting here at 7:39. Thank you.